Arizona Rules of Family Law Procedure Rule 69 provides that the parties can reach an agreement outside of court and it'll be binding as if the parties were in court. An email may be binding where the parties reach an agreement. There was a recent case where the parties negotiated back and forth to reach an agreement regarding division of assets and allocation of debts. Under this situation, the court found that there was a binding agreement between the parties which was enforceable. Typically, a Rule 69 agreement may be done in court in front of a judge, and at that point it will be put on the record, and most situations the parties then will prepare a formalized Rule 69 agreement providing all the details of the settlement. Other situations, there may be a case where the parties participate out of court in a settlement conference, and a pro tem or a volunteer judge has the legal authority to enter a binding Rule 69 agreement. In the particular case, the trial court determined that an email to be binding Rule 69 agreement and told mother that she would have to file a modification parenting time petition to modify that. The Court of Appeals agreed with father that mother had the burden of challenging the validity of the Rule 69 agreement. The court rejected mother's argument that the family court failed to make express findings as to all relevant best interest and relocation factors. When entering into a legal decision-making, custody, or parenting time arrangement, the court in entering its ruling has to make specific findings of fact so that it's detailed and the parties know exactly the basis for the court's ruling. In this particular case, the court did make those best interest and specific findings of fact, so the Court of Appeals upheld the emails between the parties as a binding Rule 69 agreement.